Thanks everyone for joining us today to talk a bit about licensing university intellectual property, or what some consider the fun part or bread and butter technology transfer. So we'll jump right in with a quick overview of things that we'll cover today. First, we'll address some basic questions, such as what is a license? Why do we license IP resulting from university research? How do we typically find these companies, the licensees? How do we negotiate? A very high-level discussion on how we approach negotiations and what we look for. Giving a high-level overview of where we're going to go, and now we'll go there. So what is a license? And I think it's important to think about this in the context of there are two basic types of IP transaction agreements. One is a license, and the other would be an assignment. And so first, when you think about an assignment, that would be a permanent transfer of ownership rights from the patent or other IP owner to the assignee. So if I have a patent and were to assign it to you for some fee or consideration, or perhaps as a gift, once that assignment was effectuated, I would have no longer have any rights with respect to the assigned patent. You, as the new patent owner, would have all control over it, even as to whether or not commercialization of that invention is pursued, or if you even pay the periodic maintenance fees as the assignee of that. Control would be entirely yours. A license, on the other hand, much preferred approach for universities, given that university technology, when it's licensed, is still at a relatively very early stage. And so our interest and what we want to see and encourage is that our licensees, those companies that license our early stage technologies, are committed to pursuing further development of that, whether it be initial, taking it through animal studies into clinical trials, regulatory approval, and so on. So if the company doesn't pursue further development and perhaps decides that they just want to exclusively license to prevent competitors from pursuing something, the license agreement allows the university to claw back or terminate the license if the licensee doesn't hold up their end of the bargain. And so various types of IP can be licensed. I'll tend to talk a lot about licensing in terms of patents, but increasingly in university tech transfer, I think we're seeing more copyright licenses, such as mobile apps, as well as licenses to proprietary biological material, research tools, and know-how. And as mentioned, the key thing here is the ability to terminate. It's not a permanent divestiture of interest in the licensed IP by the IP owner. So why do we license IP resulting from research carried out at universities? The overarching theme is we want to incentivize innovation. When new innovations reach the marketplace, they tend to improve the quality of life and provide some public benefit, which is also what the federal agencies in sponsoring research at universities expect and very much want to see. So another is that we want to foster commercial investment in development of university research, as well as promote relationships with industry, and importantly, particularly for technologies that require substantial capital investment in resources to get through that additional development and introduce to the market. Companies aren't going to want to take that risk, particularly when there's no guarantee of success or making the first commercial sale. Companies won't want to take on that risk without some guarantee of at least a limited period of market exclusivity provided by the patent term. Additionally, a mission of our office, as well as many others across the country, is to promote economic development and ensure that we see some economic return and recognition to the university. We reward innovators and their departments as colleges as well, by sharing a portion of net income, and that would be any license income we receive above and beyond the university's out-of-pocket cost, which typically the lion's share of that would be costs that we've incurred for pursuing patent protection. How are licensees typically found? And so most often, I think the best case scenario is to identify and initiate contact with a licensee from mutual cooperation between the university investigator and the licensing professional in the tech transfer office. So our office is committed to marketing technologies, and this would be in the instance, of course, where sometimes the investigator is an entrepreneur and will let you know at the outset, or perhaps you already know, that the university investigator has interest in forming a company. If they're not interested in becoming an entrepreneur or continuing to be, we support that as well. And these are, I guess, when we talk about technology marketing to establish companies and venture groups, this would be the case where the university researcher wants to maintain his or her role exclusively as the researcher and not be involved with the company. So working with the tech transfer office or the innovators will prepare a marketing abstract, what we call, which is a very high level summary. And we can do active marketing where we reach out to companies that we believe, based on our research, have the appropriate or relevant expertise and resources to bring the technology to market. You can reach out to them via email, but increasingly, LinkedIn messaging has shown to be very effective in making those contacts. We also use a website called Flintbox, which is very popular and effective for university tech transfer offices, where we take those one-page summaries and we post those descriptions of the technology and licensing opportunity on this website. It has some Google search engine optimization features that really help bring those Flintbox pages to the top of search results when certain keywords are included. So that's another way, and then of course we can't forget about the more traditional publications, the journal articles that our investigators publish, as well as patent applications, presentations at conferences, and things like that. All of those can lead to companies reaching out to us to learn more about the technology and the licensing opportunity. So when we get to that point, we're at the information exchange stage. Company has indicated they're interested in learning more, and would like to have a conference call, and perhaps, at least in the pre-COVID days, on-campus and lab visits were great for the companies to learn more. Obviously, we want to do that under a non-disclosure agreement, but there's some period of time from the initial exchange to, or the initial contact rather, to exchanging information. And then from there, we would move on to the due diligence phase. And this is going to be a two-way street. So for the prospective licensee, or first, I guess, for the university, we want to investigate the prospective licensee, assess their resources, their expertise, and capability to commercialize the technology. For the company or the prospective licensee, they're going to want to assess they want to kind of a two-pronged approach. First, they want to assess the IP rights. What is the if we have a patent application pending, they would want to review the prior art, not only the prior art that we've identified as the university, but they likely would want to do their own search and assess patentability. And second, they would probably want to do a freedom to operate assessment. And by that, what I mean by freedom to operate, I like to use a very simple analogy, but can be helpful. If I were to patent a 5-gallon bucket, let's say that no one had seen one before, 5-gallon buckets didn't exist until today. And I realized, wow, this is great for carrying different things around construction sites or whatever use you may have for the bucket. I get a patent for that. Someone else patents a handle for that bucket because they realize it makes it much easier to carry and overall just a much more helpful tool to use. So I'll be free to continue making and selling my bucket, but I couldn't attach the handle to the bucket. And likewise, the handle patent owner could sell the handle separately, but might perhaps or would need a license from me if they wanted to sell their handle with my bucket. So that's the second part of due diligence that companies, especially established companies, tend to perform is to look at the scope of IP protection that's expected to be available, and secondly, are there any freedom to operate issues, and is there any likelihood that perhaps a third-party license may be needed? So moving right along to the next step, negotiating a license. It's kind of some simple thoughts, but I think it's important to keep in mind, as with negotiating any contract, it's important to communicate clearly, listen carefully. If there are deal breakers or non-negotiable items, let those be known early on. We want to objectively consider information provided by the other party. And this could be comparable deal terms or expected profit margins. We want to consider that because we want the deal to be workable. And lastly, always remember to be honest, be nice. And our objective, also important to keep in mind, we want to ensure we negotiate a fair deal on behalf of the university and our stakeholders, not necessarily the best deal or the most lucrative deal. And frankly, if we're too aggressive in negotiating financial terms, we can end up shooting ourselves in the foot, because if we were to negotiate with a startup and have very excessive maybe milestone fees or other fees, when that startup goes to speak with potential venture groups, they're going to catch that and say, look, we would be happy to invest in your company, but for these excessive license terms that you've agreed to. So we'll end up renegotiating the license terms in that situation anyway. So also on negotiating a license, when we get to that point, there are two documents that can be helpful if time is not of the essence, and that can lead to a better and more detailed, meaningful, workable agreement. And those are a license intake form and a term sheet. So a license intake form is going to provide some very basic information about the company, who's involved in it, what are its capabilities and resources to commercialize the technology of interest to them. What does the company see as necessary steps or milestones to be completed in order to bring the technology to market? Additionally, we would ask in the intake form, what are the company's cost and time estimations for achieving these milestones? Will there be clinical or field tests required? Where will manufacturing take place? What regulatory pathway, if any, will be pursued? And how does the company plan to pay for that development work? If a company pushes back at that point and says, look, we haven't addressed this, or haven't yet figured it out, that would probably be a good indication, rather, that it's too early for licensing. The company is not quite ready, and maybe you might want to consider other possibilities, or if it's a startup, what we can do to help that company to be ready to license and hit the ground running. The second document is a term sheet, and probably most of you are familiar somewhat, or you've heard of term sheets. They're simple 2-3 page documents of key financial terms, typically. The term sheet is not the same as an agreement, and in fact, we always want to include a disclaimer to make clear that only a definitive agreement signed by authorized representatives of the university and the company would be a binding agreement. And so both of these documents, as mentioned, can really help expedite preparing that initial draft of the license document. So moving on to anatomy of a license agreement, obviously we'll want to include some language to describe with some clarity and specificity the license grant. Is it exclusive or non-exclusive? Certain technologies, such as software to be used for internal purposes, lend themselves to non-exclusive licensing arrangements. Others, again, that require large investment to get to market, will be exclusive licenses. The field of use. So when we grant a license, we specify what's the field of use. Is it all fields, or if the technology has multiple potential applications, we would want to carve out the field, or we would want to narrow the field of use only to that which the company intends to commercialize in. So an example here might be a technology relating to more accurate or better X-rays. And so it would have potential applications in not only human healthcare, but perhaps veterinary applications. And so in licensing that technology to a veterinary company, we would want to limit the field of use to animal care, so that we would still have the ability to exclusively license the same in a different field of use to a human health company. We address sub-licensing rights, and typically exclusive licenses will have the ability to sub-license, provided that we receive unredacted copies of sub-license agreements, copies of reports and received from the sub-licensee, and a percentage of any license income that the licensee receives from its sub-licensee. I want to define the term of the license agreement. Is it perpetual or fixed duration? The university's rights for internal use. This would be, we want to retain the right to use the technology for non-commercial academic research, as well as to allow other universities to do the same, which can be helpful if, for example, Dr. Smith creates an invention at the University of Kentucky. We license it exclusively, and Dr. Smith moves on to another university. We would want to allow them, Dr. Smith, to practice the research in his capacity as a researcher at the other university. And then if the government or if federal funding was used to support the invention, we will want to include rights with respect to the U.S. government, which would be a non-exclusive royalty-free license for the U.S. government to use the technology. So non-financial terms, we think about what do we include in the license that are not necessarily financial terms. One would be periodic reporting. At least twice per year, we want to ensure that our licensee is reporting to us to let us know what they're doing in the way of further development. How are they coming along and reaching those milestones that we agreed upon and set forth in the license agreement? Perhaps they're right on track, or perhaps they fall a bit behind schedule, and we might need to revisit and negotiate those minimum effort milestones. And these can typically, well, importantly, we want to ensure that the milestones, the minimum effort milestones we include in a license are consistent with the company's plans. And they generally kind of fall into 4 categories. They can relate to company viability, financing, manufacturing, and operations. So an example might be within 1 year from the effective date of the license, the licensee will obtain at least $1 million in funding for further R&D. Another category would be technology development. For example, to fabricate and test a functional prototype within X months of signing the license. Regulatory approval, if it's applicable, and others can relate to broad commercialization, encouraging a first sale by a certain date, or entering sales in other territories beyond the U.S. by another date. And so then if we think about moving on in the anatomy of a license agreement, financial terms, we can include an upfront fee and or equity stake in a company, where the university will take an ownership stake in the company. And in exchange, we would ask for either less of an upfront fee or none. Patent prosecution, while not strictly a financial term, there are financial aspects to it. I guess non-financially, we want to address who's responsible for what we call leading prosecution, for directing the patent attorneys what to file and when to file, when to pay those maintenance fees, and who's responsible for those costs. Typically, our preference is for the university, for us, the OTC, to continue to lead patent prosecution under a license agreement, and to copy the appropriate person within the licensee company on correspondence we have with patent counsel relating to filing applications, how we're going to respond to office actions and things like that. We will pay our law firms for those ongoing costs and then submit an invoice or a bill to the licensee to reimburse us for those costs as they're incurred. Another financial term, of course, would be royalties as a percentage of net sales. And these are going to vary somewhat, I don't know if widely is the word, but royalty rates will vary depending on the technology, the development stage, how far along is it, profit margins in the applicable market, and other payment obligations under the license. So it can be somewhat of a sliding scale. If we have, let's say, some milestone fees that are going to be paid at certain times throughout the life of the license, we can agree to a somewhat lower royalty rate. Minimum annual royalties, these would come into play if, let's say hypothetically, a technology can reasonably be expected to reach the market in 4 years, and we sign a license agreement today. We might say that in the 5th year of the license agreement, a minimum annual royalty of some probably modest amount would be due. And so to the extent that the royalties that are actually due in that 5th year, let's say if it's $5,000 is the minimum. And if we end up in year 5 getting royalties in the amount of $3,500, well, that's $1,500 short of the minimum annual royalties for that 5th year. And so the licensee would, we would ask that they pay the $1,500 to make up the difference. Another is license income. So if our exclusive licensees turn around and sub-license rights to a third party to make and use and sell the invention, we would expect some percentage of any license income they receive from their sub-licensee, with some exclusions. For example, if royalties, we expect a pass-through royalty, meaning we get the same, let's say it's 3%, we would get that same 3%, regardless of who made that sale to the end user, whether it be our licensee or the sub. We would still get the 3%. So if the sub-licensee charges, or I'm sorry, if the licensee charges 7% in their sub-license agreement, we would still get the 3%, but they would keep the 4%. And then obviously there can be some exclusions from that as well. If perhaps the sub-licensee pays our licensee cost for providing a prototype just to determine, to assess feasibility, we can exclude out or carve out that such that it would not be included in what we define as sub-license income, a percentage of which would be shared with the university. And then there are milestone fees, which can be triggered at any time. This is the one where I do understand the licensee's perspective when they push back a bit, because sometimes you see a typical milestone fee might be upon receiving FDA approval in the United States or equivalent regulatory approval in another country. The licensee would pay $50,000 or $100,000 or whatever number it may be. The rationale or justification for that is that at that point in time, the company is in a great position to make that payment because they just had a major success and perhaps they've received some related investment. On the other hand, I can also understand the argument that these milestone fees seem a bit punitive. For the company doing a great thing, which is beneficial for not only them, but very beneficial for the university as well, that they shouldn't be required to pay a milestone fee. So I can see that going both ways, but if the royalty rate is reasonable, I guess I'm okay with minimizing or deleting milestones in certain instances. One last slide on financial terms. So overall approach, and this is probably no surprise to anyone, but for an established, let's say a publicly traded company, we're not going to take equity in that company. They wouldn't agree to that, but we can agree to, we would ask for a larger upfront fee and probably larger periodic or annual license fees given the company's resources. Startups, on the other hand, we're usually going to back-end load those deals, meaning modest financial terms early on, equity in lieu of any upfront fees, and then structure the deal such that when the license or when the startup really starts to ramp up and have successes, then we start to see more return through the license as well. So now when it comes to drafting license agreements, we have all the information that we need from the prospective licensee. We have the intake form, the term sheet, and so on. Now we're ready to just put this document together. And so usually you start with, the whereas clauses. And while they, this would be after the preamble on the first page, whereas the university has done this, and whereas the company is in this field of, or this business and has this interest. I think early on, I tended to overlook these and not view them as important. But over the years, I've grown to appreciate them more, particularly when I pick up an agreement that I'm not familiar with, that maybe was negotiated 10 years ago. Having that background and context is really helpful. But it's usually a good place to start, and I think it also helps frame your mind as to how we want this deal to read, or what are the related circumstances leading up to it. And then one of the most, if not the most important things, is to very carefully define certain terms throughout the agreement. We talked about the field of use, and so obviously you want to define that very clearly. If the field, for example, is internal use only, what does that mean? Does that mean in any manufacturing facility that the company or its subsidiaries may own throughout the U.S. or throughout the world? What's the licensed product and processes as well? Net sales, and what is a sale? As simple as that may sound, we want to define what that is. And net sales is important because typically royalties are going to be a percentage of net sales. And so what's the difference between net and gross sales would be as defined in the license, and those can vary somewhat widely, university to university. Commonly negotiated license provisions, field of use, as mentioned earlier, sublicense rights, publication rights. The company may not, the licensee may want our researchers to hold off or not publish additional papers related to the licensed invention. We can't agree to that, but we can, however, say, look, anytime Professor Smith wants to publish about research, ongoing research related to the invention, we will allow the licensee some period of time to review those and comment or raise any concerns they might have before it's submitted for publication. We'll talk about transfer assignment by a licensee, and we'll typically allow this in connection with an acquisition if our licensee is acquired by a larger company, so long as the acquiring company agrees to be bound by all terms and conditions set forth in the agreement. Rights and obligations concerning improvements, something that we usually spend some time addressing. Retained rights mentioned above, and enforcement rights. So if in the event that a third party is infringing patent portfolio that we've exclusively licensed, who between us and our licensee will have the right to first pursue an infringement action against that third party. We'll typically allow our licensees to take the first pass at that and agree to assist them with any related depositions or other things that might be required in the course of pursuing that infringement action. So the UK Startup License Program, the big idea here is our office has grown considerably in the past 3 years. We have a new ventures team that is very experienced and capable and eager to assist our startups to help position them to be in the best position to really hit the ground running when a license is signed. And so what this startup license program is all about is if a startup is willing to engage with the new ventures team to do whatever it is that the company may need some assistance with, customer discovery, or really developing a business action plan of here's what steps we're going to take once we receive the license. We can provide up to a year for the company to work with the new ventures team, and in exchange for that, upon successfully completing that, what we call the option period, the startup then has the ability to enter into a license for the technology of interest under an agreement with fixed deal terms. These are set non-negotiable deal terms that are favorable to the company. This includes no upfront license fee, a small equity stake, waiver and deferment of certain pre-licensed patent expenses, which can be considerable. A preferable royalty rate, which would be lower than industry standards. And it depends on the technology area. For industrial manufacturing processes, 1%, drugs and therapeutics, 2% royalty. And for all other technologies would be a 3% royalty. No milestone payments. For additional information, please visit the link there, or I'll be happy to talk with anyone more about this program that we're very excited about. So once we get the get through the license negotiation period, both parties have signed off, the agreement is in place, that's great. And so as we grow up, or as any office grows a large portfolio of technology licenses, the importance of monitoring these existing agreements becomes increasingly more important. We want to monitor for financial terms as well as non-financial terms. Are we receiving the payments or other amounts that were agreed upon in the license? Is the licensee continuing to diligently pursue commercialization of the licensed technology? And again, sometimes those minimum effort or development milestones can be amended if needed and justified. And then, of course, part of this also includes distribution of net license income. And so according to University of Kentucky policy, 40% of net income is going to go back to the inventors, 20% to their respective college, and 20% to their department, and about 20% will go back to the UK Research Foundation to support further research efforts. And then we get to the end of the road. So everything has to come to an end, and licenses are typically kind of expire or terminate or end in one of two ways. Expiration. If it's a patent license, typically it's going to be the last to expire of the licensed patents. If an expiration date is specified, as you would more often see in biological materials license, it's important to ask what happens after the expiration. Is that licensee still free to use it, or does an amendment need to be made, or perhaps a new agreement? Something that's sometimes overlooked. And then termination of license agreements. Although we set out these procedures for terminating agreements when the licensee doesn't hold up their end of the bargain, and terminating them is not always easy. It can be messy, and because it depends on what is a material breach of the contract of the license agreement, what amounts to a material breach and what doesn't. There can be reasonable differences of opinion there. The easiest and best would be if the licensee acknowledges, look, this is no longer of interest to us, we'll be happy to mutually terminate. And this can be a simple 1- to 2-page agreement signed by both parties, agreeing that the license is no longer enforceable, it's terminated. And if you have something that clear, it's nice because it allows us to approach other companies who may have interest in pursuing commercialization. So that gets us to the end. Happy to field any questions anyone may have.
Thanks, Eric. We do have a few questions, and just to remind you to please put any questions you have in the chat button and we'll get those answered. The first question, Eric, is how does an inventor begin the licensing process?
Assuming that, well, if he or she hasn't already submitted an invention report, that would be the first step to let our office know about what it is that they see as a licensing opportunity. And then, as mentioned in the slides, if they want to start the licensing process, if they have a startup, that's one story. But if they have identified a licensee or industry contract that they think may be interested, our team would be happy to work with them and reach out directly to that licensee. But the first step would be, I think, submitting the invention report to our office.
Thank you. Another question is, when IP is jointly owned between 2 or more universities, how do you decide which institution will be the lead for marketing the technology to target companies, patenting, and licensing?
Sure. So on the front end, we call it, when the invention report is submitted, it would indicate that potential inventors include so-and-so from UK, and then these other researchers from another university. And at that time, that's a good time to get in touch with that other university's tech transfer office to see how they like to go about between the two schools, who would like to be responsible or is more appropriately situated to be responsible for taking the lead in patenting and licensing. Importantly, too, so we'll get what we call an interinstitutional agreement in place. And this agreement will not only set forth or identify the lead institution for patenting, marketing, and licensing, it will also set forth the percent splits, how we're going to share, one, responsibility for patent cost, and two, how license income will be shared between the two institutions, two or more. It could be any number.
Okay, thank you. Another question, excuse me, WIPO gives guidelines for drafting patent applications. Are there any such guidelines for drafting license agreements?
There are. That's a good question. You know, and I've seen others who have implemented checklists for internal use. You know, so our office, if we were to adopt this checklist, could use it as well. And I'm all for that. I can't think of one that really stands out, but there are certainly some out there that provide overview on recommendations for licensing.
And how does the OTC approach licensing of innovations related to addressing the COVID-19 pandemic?
Sure. So that's something that we implemented in the spring, a new, I guess, policy towards how are we going to handle licensing of or innovations that are related to addressing the COVID-19 pandemic. And so we will gladly enter into, and quickly, what we call NERFs, N-E-R-F, and that stands for non-exclusive royalty-free licenses. These are, you know, the intent is to help expedite the transfer of these technologies to help address everyone's response to COVID. No cost. In fact, we did one recently, an agreement with a healthcare system for a screening tool, a web-based screening tool developed by UK Healthcare for screening patients and employees for COVID.
Thank you. Can you provide some examples of successful licenses and how the negotiation process went?
Successful licenses. I don't want to mention any, probably err on the side of caution, any companies by name or divulge anything confidential, but overall, you know, successful licenses tend to be I've had the best with usually some outside involvement from the company, and by that I mean someone maybe with if it's a startup with relevant industry experience, and they have counsel or legal counsel to help them negotiate a license agreement. And the best ones are typically not done in just a few days or even a week, but takes some real thought, back and forth, negotiation, and then once we get to the end, those tend to be very meaningful licenses, and the company seems well positioned.
We have another question. You said the OTC can help find a licensee if we do not have one identified. Is that correct?
Absolutely. We're happy to work, and that's a major focus of our team, the commercialization and licensing team, to work with innovators to prepare those marketing summaries. We'll provide a first draft, welcome the inventor's feedback and any updates he may have or she to the development stage. We'll identify a list of companies we think could be suitable targets, and always welcome the inventor's input along the way.
Great. Another question, does your office have a standard IIA template? And if so, is that information available? We do. A lot of universities in the US and beyond have adopted what's called the model IIA template. If you Google it, Google search that, you can find it. Or if anyone wants to shoot me an email, I'll be happy to share the template with them. But the number of universities use it, and it really does help to expedite getting these agreements in place. Thanks, Eric. Just want to check one last time to see if anyone else has any additional questions before we end. And while we're waiting to see if we have additional questions, I want to let everyone know that our next webinar for September is on the 9th, and it is on the topic of how do we market technology. And Eric mentioned earlier on that we use Flintbox and some other methods, and this will go a little bit more deeper into how we do that. And I don't see any other questions. Can close out. Thank you so much, Eric, for this presentation. And
Great.
look forward to seeing everyone at our September webinar. And you can register for that by going to the Office of Technology Commercialization's website. Thank you.
Thank you, Jackie. Thanks, everyone.